Okay, the first conceptual point I want to make strong, it's a proposition. It is that the new generation of global governance, of economic global governance, treaties, organizations, whatever they are, we had the Canada-US Free Trade Agreement, we had the North American Free Trade Agreement, and for us in North America, there was then the World Trade Organization. There are lots of others that affect different regions, but these three need to be considered or recognized as having constitutional significance. And on two levels. One can say that they are so powerful. Did Sylvia Austria, you said, spoke here? No. Well, Sylvia Austria, who was a major figure in Canadian trade world, called the World Trade Organization a Mercedes-Benz of international institutions. It was a newly powerful institution because unlike other international public law institutions, it had muscle and its norms could be enforced. So that's the point I want to develop, that whether you see it as a totality, we can say it's a supra-constitution because the world has been reconstituted in the economic era for investment and trade purposes. And then from the point of view of an individual state, it forms the state's external constitution. So we have the British North America Act, et cetera, the Constitution Act of Canada, 1982. But we need to recognize we also have an external constitution because it looks like a constitution, it smells like a constitution, it acts like a constitution, and even if it isn't called one, it is. For 4 or 5 reasons. It has norms, firstly. It's got norms like national treatment. No, they may sound bland. National treatment is very, who cares kind of phrase. But it means, in effect, that governments who have signed on to this Constitution have to give foreign corporations the same benefits that they give domestic corporations. And that has consequences. It means that countries can no longer have industrial strategies aimed to promote their own companies. Not just norms, they're rules in the external constitution. In the original Canada-US Free Trade Agreement, you will remember that there are rules which prevent Canada from having a national energy program because we are not allowed to have a two-price system. We can't charge more for our exported oil than for the oil we consume domestically, and we can't even reduce the supply of oil, that is, until it runs out. So there are rules. One could go over them, the subsidy rules, all sorts of rules. So they're norms, they're rules, they're rights, intellectual property rights. We'll come back to that a bit later. And there are, so these are the characteristics of a constitution. And the reason one has to, now, other aspects of global governance have norms and rules, and they declare rights for children or rights for women or rights for indigenous peoples. But these organizations, what makes them constitutional is that in their institutions, they have a judicial capacity and a coercive capacity so that the norms and rules and rights can be interpreted by some kind of judicial process, and the results, the rulings, can then be enforced. So that's the first really crucial conceptual point I want to make. Now, there's lots of debate about this. I have a colleague at the University of Toronto called David Schneiderman who's written a book more or less with Constitution in the title talking about these trade agreements, and but I think it's probably a minority in the legal profession that would accept this conceptualization, but that's where I start. And we can be glad to debate. Now, this Constitution has a static element to it, namely the actual rules themselves, and as I suggested, and I don't want to take too much time so we can have discussion, but as I suggested, they are themselves important because it means that, and one can see that the more a country's constitution was out of sync with the new institutions, the greater impact the super constitution had on it, because its external constitution imposed more, brought in more changes. For instance, in Mexico, when Mexico signed NAFTA, it had to introduce in its legal system a whole enclave, which was, and the Mexican legal system comes out of the Spanish and continental European tradition of the civil code, not out of the common law. But Mexico had to introduce, to put a kind of implant in its judicial process, which was common law for business, so that anti-dumping, countervailing duty actions could be dealt with in the same way, so that American businesses and Canadian businesses would feel quite at home dealing with a Mexican anti-dumping case or a Mexican countervail case. So for one could put Canada in the middle, we had to make significant, I'd say the external constitution is significant, not as significant as it was for Mexico. And for the United States, it's probably a very low significance, largely because the norms in the new treaties, the new institutions, were very much projections of US domestic, and particularly in administrative law, but you would know that better than I, onto the global level. So it didn't require the United States to make much change, and then we'll see that they didn't always feel they had to conform when they lost a case. So that's the first, so that's the static, but still very, very important aspect of these agreements that changes, it creates a new constitutional reality in the states that sign on. And then the dynamic aspect of these constitutions is I think what you people refer to in terms of the living tree. Those rules and norms are given meaning, maybe even new meaning, as they're interpreted when cases are fought out over the meaning of whatever the right is. On the one hand, and then on the other, the Constitution can grow in the sense if the institution makes changes, let's say the Doha round, if it ever came to an end, to a successful conclusion, it would add new rules to what the WTO means. So that's the first thing I wanted to say. And that represents more or less the work that went into a book I published in 2002 called Uncle Sam and Us. And I should say, and it wasn't just a joke when I was referring to the colleagues that I met in Florence. The idea of the external constitution came to me because Francis Snyder was doing a course for European students on the Constitution of Europe, and that was based on thinking how important the Treaty of Rome is, and the Treaty of Paris, and Maastricht, and if you put, as he put them all together, he was saying, well, you know, there's a court, we have a court, there's a parliament, there's a legislative capacity, there's a legal capacity, there's a commission, and then there are all these rules. And even though they hadn't yet been put together as a constitution formally, he was saying, well, we have a virtual constitution already in Europe, and that's what gave me the idea when I came back to work in North America about NAFTA. So that's the first point. The second then is talking about, so that's the new governance, and the second thing I wanted to go on to from that is North American governance. Now, and that represents work I did that I published a few years ago in a book, okay, actually it was last year, 2008, sorry. It's a book that was a product of a lot of work with students of mine, and I always talk to them about the big boring book that we were going to produce, and if we had 8 readers that would be terrific, but we had to get it right anyway, and so it became referred to as the BBB. A student would send me a message, please send me chapter 2 of the draft of the BBB. The BBB was asked a question. It was, does North America exist? And it was very much came out of what I had learned in Europe 15 years ago about the Europe of the European community, the Europe of the European Union, a transnational, almost supranational region that had significant governance, even government in the authoritative decisions made by the European Court of Justice, but governance in the sense of significant non-state actors like business or NGOs working transnationally and for better or for worse, whatever one thought of it. And my question was whether North America was anything like a region, a global region in the sense that governments accept some kind of control, some kind of significant control, or they agree to decisions made by bodies they don't control, like the European Commission. That was the question, and I came to 4.5 answers. And I'd like to go over them quickly. The first was on the institutional side of North America. That is what NAFTA created as institutions. And it was obvious from the beginning that in legislative capacity, NAFTA had 0. In executive capacity, it had a North America Free Trade Commission, so that sounded, and it had responsibilities specified in NAFTA. But in fact, the North America Free Trade Commission never had an address. That is, it never had a building, it never had a staff, it never had really an existence other than the occasional meetings of the trade minister, the Canadian trade minister, the Mexican secretary of the economy, and the US trade representative. So it didn't have a legislator or an executive. As far as an administration go, it had a couple of dozen of working groups, but some of them didn't even meet, and all of them were inconsequential. They were maybe civil servants got together occasionally, and even those occasions became quite rare. However, it did have some judicial capacity, and that, when we were engaged in the debate about the Canada-US Free Trade Agreement, was and Alan Gottlieb was very much involved in the deal at the end, which saved the negotiations. It had 6 judicial processes, arbitration processes. 2 of those are, what is the word, dormant. The Energy and Finance chapter had dispute processes, but they've never ever been used. 2 of them were successfully designed to be ineffectual. That's the North American Environmental Commission dispute process and the North American Labor Commission dispute process. So complicated. I talked to one of the people who had been involved in working out the details. He was a Republican, and he was very pleased that they made it so that it couldn't work. So the labor movement and the environmental movement in the US who had supported Clinton could be satisfied that something had been created, and the Mexican government, which was against the whole process, could be satisfied that it would never ever suffer from this legal process. And then that leaves 3 that seemed to be of some significance. Chapter 20 of NAFTA set up a process for ruling on issues when the 3 governments had some dispute about the meaning of a provision in the agreement. And that was not what we would call government, because the panel, when it reported, only advised the North America Free Trade Commission, and then the North America Free Trade Commission advised its 3 governments. And as Mexico found out when it pursued the United States for not complying with the obligation to allow Mexican trucks to cross the border into the United States and actually go as far as Chicago to deliver their load, which the United States refused to allow, Mexico ultimately won the Chapter 20 panel ruling, but it made no difference. They are still not allowed across the border. They're allowed across the border, but they have then to unload onto an American truck. So Chapter 20 turned out to be of no significance. Chapter 19 is something that some of you may make your fortune on, because that's what has to do with anti-dumping and countervailing duty actions. And that gives a company, through its government, the chance to, or even directly to, set up an appeal process against a determination. So it can be an American company against a Canadian determination, or a Canadian company against an American determination. and it's meant to allow for a binational panel to rule instead of appealing through the respective administrations' appeal process. And that is pretty well, and that's worked well for small conflicts, and it's famously come to a grisly end with the softwood lumber case, because Canada won most of the rulings, including at the WTO panels, on the US countervailing and anti-dumping duties against Canadian softwood lumber. And the United States proceeded not to comply, and the Harper government capitulated, as you may remember, a few years ago. And that leaves Chapter 11 of NAFTA. Chapter 11 is about investment, and Chapter 11 has a radical new arbitration system. Now, I'm not accurate when I say new, because it had been developing in international corporate law under the International Chambers of Commerce since World War I, and it had been used basically by ex-imperial governments dealing with ex-colonies to impose a legal regime so that should, let's say, a British company be nationalized in Ghana, there could be a process that would bypass Ghanaian courts and provide, let's say, I don't know, Land Rover, whoever, a British company, with a way to get justice without having to be concerned about possibly corrupt ex-colonial courts. And so that principle that investors could sue states directly was already contained in bilateral investment treaties. What was new was that this, for the first time, was applied to two developed countries, namely Canada and the United States. And some of you know very well, probably better than I, how much, what kind of a, well, innovation it certainly is, what kind of an affront to our legal and democratic values this process is, given that the arbitration takes place under rules of secrecy, given that the arbitration takes place in courts of 3 arbitrators, one of whom is appointed by the corporation that is suing the government in question, that given that the arbitrators themselves have a commercial interest in the clients, in the plaintiff as possible future or often past client. And I could go on, but some of you may want to challenge that, but one can, if you know the name Gus Van Harten, you will know that he is trying to do something about this. In any case, the first answer to my question, does North America exist, was that in governance terms, it was much less than met the eye. Because one talked about, in those days about NAFTA as if it had created a new North America. And apart from that Chapter 11 dispute settlement, which in context is quite minor, although in principle is quite major, the answer was far less than met the eye. Second answer was that North America was more than met the eye. I do political economy. If you look at certain economic sectors in North America, you could see that there was a increasingly integrated market. Take beef, take wheat, take corn, for instance, in agriculture. Now, in terms of our interest in law or politics, what then becomes interesting is what happens when there's a conflict between 2 or 3 of the countries. And beef gave us an example. I think it was, 2003? A mad cow was discovered in Alberta. That was a godsend for the American ranchers south of the Albertan border, because they could get a barrier put up to Canadian beef crossing the border. Now, of course, the Canadian government protested, and of course, the American government sort of said nice things to Ottawa. The dispute was resolved not by Canada, United States law. It was resolved because in the transnationalization of the Canadian economy, there were more and more American companies that were involved in the food processing system in Canada. And even those who weren't wanted Canadian cows for their food processing in the United States. And it was their fight with the ranchers within the process of American politics, of the administrative law system established in Washington, that process was resolved in Canada's favor, but not because of Canada's action. And the same story can be told about wheat, because our same friends south of the border out in the Midwest have chronically felt that the Canadian Wheat Board is a socialist conspiracy and should be abolished. And they have had action after action against Canadian wheat on the grounds that it is subsidized by the Kanukistan Wheat Board. And that issue, too, was fought out between more the food transport industry, the Cargills, but in Washington against the ranchers. So that's not to go in any greater length. So in that sense, the second answer is that yes, North America does exist, even though we don't sort of see it every day in that form, but it has a very specific quality, which is the power center is even more in Washington than it was before, in my view. The third answer is North America is not at all what it seems. And you can find some sectors, and I'll just mention one because I think it will touch a lot of your interests as lawyers. Intellectual property rights is an interesting example. And I wanted actually to preface this by just a little sidebar. As Canadians, we hear time and time again from Ottawa that we need, as a middle power, not a powerful power, we need to live in a rules-based system. And that's why these trade agreements are so important, because it gives us rules which will govern the big guys, like people next door. That proposition does not ask the prior question, how are the rules made? And I think we need always to be conscious of the way that rules are made, and I think it's pretty clear if you think of, well, the intellectual property rights rules in the World Trade Organization are a wonderful example of how rules were made in a power-based system. And to put it very briefly, it was the knowledge-based industries in the United States, that's the Microsofts, on intellectual IT, intellectual technology, information technology. It was the Monsantos, the bio food people. It was the Disneys, the entertainment. It was the Pfizers, the legal drug people who wanted to have, and the bright idea was to put into the trade regime intellectual property rights. Now, intellectual property rights, by the way, have nothing much to do with trade. Trade is about trade liberalization, freeing up, and property rights are creating monopoly rights. But that aside, the way that, the way that the TRIPS agreement emerged, the trade-related aspects of intellectual property rights, which is part of the WTO of 1995, the way that happened is that the American industry was very smart. They got together with their competitors in Europe. They got together with their competitors in Japan, and they said, listen, we will all be better off if we have a powerful global intellectual property rights regime. And with that consensus in the three prime negotiating powers, Europe, the US, and Japan, TRIPS, lo and behold, was put into the what was it called? This single undertaking of the WTO. Now, Chapter 17 of NAFTA is pretty well identical to TRIPS, and it was put in there because there was a blockage in the Uruguay round negotiation, and it was a tactical move of the United States to get a precedent into a trade agreement. However, my point is that North America is not what it looks like in some sectors. Intellectual property rights is the example, because even if Chapter 17 is more or less the same as TRIPS, it's dormant, it's not used. Why is it not used? Because, for one thing, the WTO has a more powerful dispute settlement system, more effective, more neutral. You don't have members from any of the parties, any of the, I was going to say belligerents, any of the contesting parties are not on the panels, whereas NAFTA panels have Americans and Canadians judging the issue. And for another, but more important still, if Pfizer wins a case against Canada through the WTO's process, that ruling is going to be valid in India or in Australia or anywhere else, because it's a global ruling. Whereas if they win a case against Canada through a NAFTA case, that's going to be valid in Mexico and the US. So this, the point here is that North America is not what it seems in some areas, where in effect where those sectors are, to the extent they are governed beyond the state, they're governed globally and not, and you could say that same about banking and some other sectors. Okay, I said there were 4.5 answers. The half answer is that some of these, and this finding has to do with the eternal length of time it takes to do a piece of work. Because if I'd published my big boring book when I had started I guess around 2002, I would have said that there were a lot of sectors in this category of where North America is more than meets the eye. But as time went on, and steel is a terrific example. In the steel industries of the three countries, there was a cooperation between the government and the steel industry at a trilateral level. For instance, the OECD asked North American countries, what is your position on the next round of negotiations on steel? What are you guys after? And the Canadian government got together with the Canadian, whatever, Steel Association. The US got together with the AISI, the American Institute for, the American Iron and Steel Institute. And the Mexicans got together with their guys. And the three of them got together. They have a North American Steel Committee. And if a social scientist is allowed to get excited, I got quite excited about this, because here was continental governance happening, driven by the market, but also driven from government and connected globally, and it all looked terrific. And that's what my big boring book would have said. Luckily, it took longer to get finished, than 5 minutes. And in 2006, was it 2007, 2006, 2007, in the space of 18 months, the 6 biggest Canadian steel companies, and Canadian steel had been an enormous economic and policy success story in Canada. High tech, high efficiency, high quality, Canadian ownership, Canadian technology was a huge success story. These were very competitive companies, much more efficient than American companies, even more efficient than European. They were all bought out by foreign corporations, Brazilian, Indian, and then ultimately US Steel bought Stelco. The point is that there are sectors that are moving from my second category to the third, from the continental regional category to global. And you could say the same thing about the automobile industry. It's become globally restructured in terms of ownership. That doesn't mean to say that the North American steel industry does not exist and that there isn't a North American market, and it does. And I think what's very interesting and what does not bode well for your incomes if you go into antitrust corporate law is that because Mittal, for instance, the Indian company, bought out Dofasco and has therefore a plant in Monterrey where Dofasco was setting up the flat-rolled steel plant for the automobile industry in Mexico. Because these global transnationals are operating in North America, in fact, this AIS, the American Iron and Steel Institute, the more companies are foreign companies, members in the AISI than there are American steel companies, then they are not doing anti-dumping actions against each other. So there's been, through this globalization of the North American steel industry, there's actually been more integration of the market. And down the road here in Hamilton, the former Dofasco, now Mittal, Arcelor company is where the center for the North American center for this kind of steel, the flat roll steel for the automobile industry. Okay, so that's the 3.5 answers. It's more than meets the eye. It's not what meets the eye, but it seems to be that the trend is for what used to be continental sectors becoming globalized. Now, so that's 3.5. The fourth answer is that North America, since 9/11, which is also part of my improv task, since 9/11, North America is just what it seems, namely intergovernmental relations driven by Washington. Intergovernmental relations driven by Washington's anti-terrorist paranoia, to be a little more specific. And the new security North America, now this is not what NAFTA created, it's what happened afterwards. The new security North America is far more harmonized than the Council of Canadians or the Canadian Centre for Policy Alternatives was ever fighting against in the free trade debate, because the United States has imposed its muscle, that is, say if you want to get your trucks across our border, then they're going to have to conform to the following criteria. And the integration of our systems through the new Patriot Act, which we have mirrored in Parliament under the already under the Chrétien Liberals, has created a real North American governance which has paradoxical components. It's very much driven by US demands because of their psychic need to have total security against Osama bin Laden's second cousin once removed, coming to Montreal, maybe getting across the St. Lawrence River. But they also then require or need the Mexican and Canadian governments to deliver on the visa requirements for foreigners coming to the continent, or for intelligence cooperation, or for data transmission of, when you buy a ticket, it'll be registered somewhere in the U.S. Data system if you're getting onto a plane. And so that puts the United States into something of a dependent situation in that for their system to work continentally, for their security perimeter to extend not just to the 49th parallel, but to the Northwest Passage, then they require the Canadian state or they have to hope that the Canadian state will meet its commitments. Now, that's not such a big problem. It is a problem south of the Rio Grande, however, because the Mexican state is not rich. The Mexican state is not very effective, and it puts the United States in the position of demanding certain things, but then having to pay for the equipment that would be required for these measures to be implemented. So the end of this analysis is, this stage of the analysis is that to the question, does North America exist? The answer is, in terms of economic governance, barely. And that it strikes me that it's not, this is sort of more a political economy statement, but it's not appropriate to talk about North America as if it were a global region in the same breath that we talk about Mercosur, maybe in South America, or ASEAN, the Association of Southeast Asian Nations, which seems to be effective and in a fairly cooperative, consensual way, because the hegemon, the big guy, does not really feel constrained by the rules that it has caused to be written for his two partners on either side of the border. And maybe it happened too late, but I think one can say fairly, with maybe the exception of cap and trade a cap-and-trade environmental climate control possible approach, that North America is either too small, it's too small for the auto industry because they want regulations that are for their global cars, and it's too big for most other issues. And it doesn't seem to be the right size to work, or it happened too late, or it happened because there's such an asymmetry of power between the major company and the minor ones, the major country and the minor ones, that it's not reasonable to expect the United States to agree to be bound by its commitments. Now, I wanted to go on to more briefly just to a couple of issues outside the NAFTA North America, and that's where we come to Narcos that were in the title, and that's the only reason that most of you came, I presume. If I ask a question, how many have not tried marijuana? And I put my hand up. I don't know if any of you would put your hand up. A few would probably. If I ask the question, how many have not? I wouldn't want to embarrass you. There's a camera up there. But I'm probably not going to run for office any longer. Toronto was saved. Professor Carmody, to my embarrassment, mentioned that I'd run for mayor. And I didn't run against as big a fossil as our new fossil in Toronto. But luckily for Toronto, I lost. But so I'm not worrying about running for office again, so I can even say that I inhaled. But if I asked how many have not tried ecstasy, they would probably, I could say that I had not tried ecstasy. How many had not tried cocaine? You know, I won't press the question, but I wanted to make the point that with marijuana, with cocaine, with ecstasy, we are dealing with a huge industry. We are dealing with a huge industry that is continentally integrated. We're dealing with industry in which Canada and Mexico are major threats, are seen as major threats to the United States, because whatever you call it, I'm playing with the notion of illegal civil society. The gangs the Asian gangs, the non-Asian gangs in Canada, the cartels in Mexico, supply that they produce they're the largest producers of 4 of the 5 major narcotics that are supplied to the huge American market, and they're the major suppliers of all 5. They don't, cocaine is not produced in large quantities in Mexico or Canada, but because of the success of the United States in stopping shipments of coke from Colombia through the Caribbean, that cocaine comes through Mexico, so that Mexico, whether it makes it itself or simply delivers, these 2 countries are the chief threats to the stability of US society when you think in terms of gang violence and the general sort of collapse of American civilization. On the other hand, the governments of Canada and Mexico are the chief allies in dealing with the narcotics issue. And ever since these narcotics were prohibited, putting up the market price of their market price and criminalizing the people involved in the industry, this has created a nightmare in which Canada has been regularly working with the United States through various agreements with the RCMP, working with American authorities quite normally. I mean, it's well established and so works as well as any failing operation can work. Whereas Mexico has felt, until recently, reluctant in cooperating with the so-called war on drugs. And I say until recently because because it is getting more difficult to get drugs across the US-Mexico border, the cartels have opened a new business plan, which is to distribute in Mexico. And they, as of 2 years ago, the figure was 4 million addicts in Mexico. So they have now a local market, and that gives Mexico's governors a local problem. And the result of this is that now the Mexican government is 150% involved in fighting the drug sector, the drug industry, the drug cartels. And as you know, when Felipe Calderon was installed in power, I did not use the word elected because his election was contested by the left. And I have a friend in Mexico who is a former ambassador, and he's working for what he calls the El Presidente Legítimo, because López Obrador is considered the legitimate president by those who voted for him, even though he didn't become the actual president. But Calderon, when he came into power, sent off the army to fight the cartels. Arguably, it was disastrous, but we'll see. The point of saying all this is that we can't, or we should not talk about North America without recognizing that North American governance, which in my book has been mainly NAFTA stuff, economic governance, did not set up institutions that could cope with other issues or even fallout issues. And another major fallout issue was a product of the corn sector. Now you might say, my God, what on earth has corn got to do with something that would be significant outside the NAFTA issues themselves? What it has to do is, or what it did, the U.S. corn, the context is the U.S. corn industry was looking for a new market in the 1990s because with the collapse of the Soviet Union, they lost the Russian market for corn. And with the negotiations going on with Mexico, they pressed very, very hard to have the Mexican corn tariff lowered. The resulting flood of corn there was already U.S. corn in the Mexican market, but the new inundation led to, but from industrially produced, heavily government subsidized American corn, led to the depopulation of a lot of the pueblos, the villages in Mexico, where there was subsistence farming, and the campesino, 2 million, the general figure is 2 million campesinos left the countryside. And they left the countryside with the Mexican government wanting them to do this because it wanted to shrink the population in agriculture and build the population in the industrial sector. The only problem was that NAFTA did not create jobs other than in the maquilas on the border. And hundreds of thousands, that is, there were some years when 500,000 Mexicans found their way across the US border illegally, undocumented. But there's been a huge social or labor consequence of NAFTA in this sense, and it's a consequence for which there is no transnational or continental governance. So I just want to make the point that beyond analyzing what NAFTA has generated or not in terms of North American governance, there are aspects of it like narcotics and labor flows which are simply not touched. Okay, so I need to come to last 2 points. One was to talk about, so what does all this mean about North America now? In a word, disintegration. The Obama administration, or under the Obama administration, as we all know, has caught Canada's attention with Buy America. Buy America legislation, if it doesn't violate the letter, it certainly violates the spirit of NAFTA, which was lowering borders and continental economic integration. The Obama administration is pursuing other trade initiatives. The current one that is worrying Canada is the Trans-Pacific Partnership, from which Canada is excluded. The United States a few years ago negotiated a trade agreement with the Central American republics, CAFTA, Central American Free Trade Agreement. Mexico was excluded, and it had to bargain for 2 years to be given the same rights into the American market that the Costa Rica was given. And it had to make concessions to do that. So the sense that NAFTA created a three-government entity and that three-government entity would operate in the world as an entity is not correct. We may have hoped that, but it's not happening. So that's briefly what the United States, the way the United States is disintegrating North America. Canada has decided, the government has decided, that Mexico is a bad idea and that the Canadian government should deal bilaterally with the United States and reestablish the special relationship of the 1960s or the 1970s or whatever the golden age was that they think once existed, when NATO was important, when NORAD was important, when we were important in Washington. And just to make the point, Mr. Harper went out of his way to kick Mexico in whatever vulnerable part you may want to use to finish the sentence by requiring that Mexicans wanting to come to Canada had to have a visa, including the former foreign minister who said a year ago at a meeting in Toronto that she had never been as humiliated in an application process as the experience of going to the Canadian embassy, which it looks like a fortress actually in Mexico City, and she had to produce her mortgage, she had to produce proof of title, she had to produce documentation which was completely unreasonable, given especially that she was now, I think she's now a senator. In any case, we have now, so we've made it very clear that we are not part of North America in sort of community or identity sense. And Mexico, who's the least, in the least good position, when I was there this past winter, there was a big thing because Calderon had a meeting, I think in Cancun, of all the governments of the Western Hemisphere, except for us, except for the Anglos, Canada and the United States. So not that it's going to end up as anything, because Chavez has got his own new organization, Bolivariana, whatever. But still, Mexico made a point that it too is not necessarily part of North America. Okay, what does this lead me to in terms of conclusion? Maybe three things. One, I think for people who are concerned about the law, that we need to take very seriously these innovations in global governance which undermine the whole achievements of a number of centuries of democratic and legal development. And whatever their faults may have been and inadequacies, the development of a regime which undermines government capacity and frees corporations to attack governments without imposing any responsibilities on those corporations is a perversion that we have done to ourselves, which I take to be very, very significant. And actually, there's 2 points in conclusion. So that's the first, to pull this together. I think we have a global or an external constitution which is an outrage. And that leads me to my, since I'm in a law school, my permitted normative conclusion. I think we need to try to change that reality. I think it has to be resisted. And I don't mean just Maud Barlow going to the barricades. I think that there are plenty of good examples of successful rebalancing. It's not that it's a bad thing that there be effective global economic governance. It's that there's an imbalance. In our book's title, it's a perilous imbalance between strong economic governance and weak everything else, because the economic norms trump cultural norms or human security norms or human rights norms. And so what can be done? Well, that'll be for you to see what you do in your careers. But what has been done it's obvious I think it's going to be done. This government, not this government, the Canadian government in the 1990s was very effective. In fact, it actually took the lead in two major increments to international law. One was the treaty to ban the use of anti-personnel landmines. Now, maybe you should give the credit to the late Lady Di, but you also need to give a good deal of credit to the government of Canada in general, and Lloyd Axworthy, the foreign minister in particular. Same story for the International Criminal Court. And the International Criminal Court is more significant, not just because it's a major institution designed to bring the perpetrators of atrocities like genocide to justice, but it was created in the face of persistent, consistent opposition from the United States. And Canadian diplomats, and including Canadian politicians, played an important role. It's not to say it was Jack the Giant Killer, but Canada and the rest, most of the rest of the international community caused this to happen. So, and there's another important balancing or rebalancing achievement that we can point to that is also a Canadian initiative, and that was the consequence of Canada losing to the United States the US case against our preventing Sports Illustrated to set up a split-run magazine in Canada. And having lost that at the WTO, it's an interesting story in itself, Canada took, and it was a Canadian lawyer, Peter Grant, not at, this is Fasken Calvin's honorary room, but this was at the opposition, what's called McCarthy Tetro. Peter Grant is a communications lawyer, and it was his idea that there be another instrument, another international instrument that would provide a normative rationale for countries to have to favor their own cultures and have some barriers to Hollywood or US television. And lo and behold, and Sheila Copps led this issue successfully, and in UNESCO in October of 2005, enough countries signed this new document. It's called the Convention for the Protection and Promotion of the Diversity of Cultural Expression. So it must have been a committee that wrote that title. But so there are several examples of rebalancing that have happened. So I don't think one needs to say, oh my God, we've done this to ourselves and we're finished. We may well be finished given what's happened south of the border in the last election in terms of frying ourselves. But I think we can, and we should, and actually there's one other example, I referred to it fleetingly, but I'll bring it back. Professor Gus Van Harten at York has started a petition which has been signed by, maybe a petition isn't the right word, but he has a document that's been signed by, I don't know, 100 or so, mainly law professors, making the case against the investor-state dispute settlement process as it now is, with very clear and concrete proposals for how to reform it. And since the pen is mightier than the sword, maybe this pen will lead to some change of what I think really is an outrage. So, Professor Carmody, that's my undistinguished lecture on and the attempt to deal with Narcos, Canada-US, law, 9/11, NAFTA, and governance. Thanks very much.